Hello everyone, this is Paula Marie Young, award-winning mediator and legal educator whose purpose is to teach people negotiation and mediation skills so they can live happier lives, solve problems more effectively, and resolve conflict holistically with wisdom, skill, and heart. So, we are in class 26 still. We're still talking about ways of generating movement in the parties' positions, and we've talked about different forms of persuasion, and what this particular webinar focuses on is persuasion through feedback and evaluation. So it's especially targeted for mediators who are going to use a more evaluative style. So give me a minute and I'll get my slides. All right, so you'll remember that we've already talked about persuasion based on empathy through role reversal, persuasion through healing by using apology, and persuasion by appealing to interests and then engaging in problem solving. And now, as I've said, we're going to be talking about persuasion through doubt, providing feedback and evaluation. So, evaluation is defined as typically legal evaluation, and you're typically giving feedback on the practicality, wisdom, fairness, morality, in some rare cases, of a party's proposal or position. And you are relying typically on external standards or potentially the party's internal standards, depending on the nature of the feedback that you're giving. Persuasion is accomplished by raising doubt, and it's a very confrontational intervention, and so in terms of that list, that progressive model of persuasion, it is listed last. It carries with it the most risks in terms of being perceived as heavy-handed, as undermining party self-determination, and compromising your impartiality. So we need to recognize that there are gradations of legal evaluation, and you've already begun to see that in the questions that mediators can ask that I included in the materials on mediator style. And one of the things that you noticed was that the more heavy-handed interventions almost always were statements ending with a period, and the more elicitive, less heavy-handed approaches were questions. So you'll see here that we've kind of reversed that order. Here they're talking about the least invasive is questioning parties about elements of their cases, evidentiary problems, etc. So just kind of playing dumb and being curious and having them go through it and maybe asking questions that just begin to shake their confidence in their cases or the strength of their proof. Asking one party to respond to another party's legal arguments. So this is, how's this going to play out at trial? It's kind of a role play exercise in that sense. Providing legal information without applying it to the facts of the case. So this, for instance, in the Cross v. Rope role play, maybe you provide both parties a copy of the statute governing landlord-tenant relationships. So anyway, there are some examples in the textbook if you want to look at how they've applied this specifically. All right, now we're moving into more heavy-handed tactics. So making a prediction about an evidentiary or procedural question by applying the law to the facts. Now, frankly, under the definition in most states, anytime you're applying the law to the facts, you are engaged in legal advice, and in that case, you have now put on your lawyer hat, and you may be inappropriately mixing roles. Making a prediction about a substantive element of the case by applying the law to the facts. So again, another potential problem. We move from evidence or procedural questions to now substantive elements more likely to be deemed legal advice. Making a prediction about possible or probable, that should be probable court outcomes. Well, that's okay as long as you're not trying to predict the outcome in a specific case by a specific judge, which most ethics rules preclude. And as you see, that is the last intervention, and certainly in Virginia, that would not be a permissible intervention. But, you know, now you know that these are different approaches, and you can decide what you want to do and how far you want to go. Okay, challenges of legal evaluation. It's often greeted with considerable pushback to the bad news that you're trying to deliver. And it creates a risk that the party will perceive the mediator as partial or biased, because in order to use this to kind of shake people off their position, it almost sounds like you're aligning with the other side. Often provided in caucus, which allows more questionable mediator behavior. So if mediators aren't really adhering to their ethics values and aren't really well trained in this style, you get all sorts of weird things happening. It's very manipulative, and the caucus room creates opportunities for it. And a prediction of a court outcome is hardly science. I mean, you know, I can't predict what judges are going to do, even if I know them really well. It's hard to know what's going to happen in a particular case. Okay, effective and proper evaluation strategies. So there's quite a bit written on this anymore. It comes out of the whole debate that was surrounding Riskin's first grids about which is the best style, facilitative or evaluative. I've included what I think is one of the more thoughtful approaches to this, which is the Leela Love and John Cooley article. So I'd ask you to spend some time with it if you are planning to adopt this style. So the first thing that the author suggests is evaluate only when necessary. So this is really a last-ditch sort of impasse-breaking technique. You should be running through your entire toolbox before you get to this. If possible, evaluating caucus, because it probably has the least impact overall on party self-determination, and it also has benefits of allowing people to move off a position while saving face. And I think I'd talk about this in a future slide. Ask permission. So, you know, it's one of these things where you're not just laying it on the table, kind of like a, you know, a little piece of barf or something. You are actually being invited in to give it. So you want to ask permission for that. Be transparent and explicitly even-handed. So there's a video clip that illustrates that. If using questions to sow doubt, avoid leading rhetorical questions. So you're wanting to be very gentle about this and have these open-ended questions, or, you know, is it possible sort of questions. And I guess this video clip is going to illustrate either good practice or bad practice. I admit I haven't watched it yet, so I'm not quite sure what they're showing there. Okay, so here are the two authors of the article that I included in your materials on consent and mediation, midstream mediator evaluations and informed consent. And this appeared in the magazine that's published by the ABA section on dispute resolution. By the way, John Cooley died a couple of years ago, I guess, and Leela teaches at Cardozo Law. Very well respected, actually one of the former presidents of the ABA section of dispute resolution, somebody who's really leaned in. Okay, so a mediator engages in evaluation of legal issues only after, this is according to Love and Cooley, the parties have invited her to do so. She warns them about the risks of the evaluation to their perception of her neutrality. She warns them of the risks of the evaluation to party self-determination. She takes a day or so, whatever is necessary, to do any needed research so she can give the evaluation competently, and she does it as the last effort to avoid impasse. So you see a lot of overlap between what they're saying and what the authors of our textbook are saying. Let me focus a minute on this one, because I think probably evaluative mediators are, first of all, reluctant to ask for the opportunity to do the kind of research that they need to do. But when you step back and think about it, if a client walked into your office and described a problem, even if it was over 3 or 4 hours, which might be the length of a mediation, would you feel comfortable giving them advice at that point without doing some research? Even if you practice in the area, there could be a case that came down that you weren't yet aware of or something. And, you know, some people would say, if that's the kind of law you practice, you better be contacting your malpractice carrier. Yet in mediation, there is a strong tendency for mediators to do these sort of off-the-cuff evaluations without necessarily knowing the applicable law. So given the nature of the dispute, if it's a complex, high-value case, you could ask the parties for permission to do this. And there are other writings on ways that you can do this with a lot of care. Effective and proper evaluation strategies also include using stories, analogies, and metaphors, providing balanced evaluations. So you want to acknowledge the best parts of both cases and maybe the worst parts of both cases. When delivering bad news, externalize your predictions. So I want you to read about this in the textbook and get a better sense of what they're talking about there. Effective and proper evaluation strategies. Don't evaluate unless you know what you are talking about. So this again is, you either give it because you have a lot of training or experience in the area, or because you've taken the time to do the research. And then explain fully and don't pull any punches. So if you're going to do this, it really needs to be valuable. It really needs to be something that, especially if lawyers are involved, are going to find persuasive because it's thoughtful and it's well supported. Other strategies: provide assurance that concessions will be productive. So if you're doing this to try and get people to make more concessions, they need to feel that if they make it, there's going to be a concession coming from the other side. So that's going to require preparing both parties to make that next step. And it could even be a condition of giving the evaluation. You know, if I do this, then there's certainly going to be an expectation that you're going to make a concession in light of what the kind of feedback that I give you. In rare situations, confront. You know, I'm not sure exactly how you do that. Again, I don't really do this sort of mediation, and my concern would be that it's going to affect your sense of impartiality. I say that as I'm thinking about one of the mediations that I did in the early 90s. I was an advocate, not a mediator. We hired a very well-respected lawyer who practiced reinsurance law, and we were in a $14 million, I think it was $14 million, a $14 million case in which we were seeking payment of reinsurance proceeds into the insolvent insurance company's asset base. And the reinsurer had raised a lot of defenses that we had seen before and successfully met in other cases. It wasn't a strong defense. And we provided several boxes of exhibits to the mediator, and given the price tag on that case, we expected him to read them and be familiar with the file. And so we convene, he does his short mediator orientation, and then he turns to the counsel for the reinsurer and says, I think you're going to lose at trial. I mean, this is practically the first thing he says out of his mouth. And I looked across the table at these folks thinking, wow, did I just lose a lot of leverage in this negotiation? You know, I'm putting myself in their shoes. And they surprisingly kind of nodded their heads, yeah, we know that. So I thought that was really interesting, and I guess because we were very sophisticated parties, he could get away with that. But it's tricky. Okay, so the video clips show a range of evaluations, and here are some of the questions that the authors raise. What do you like about each evaluation style? Dislike? What are the principal differences in their approaches? What factors made each example more or less effective? And then they suggest recalling video clip 9G, which is the one I hadn't watched yet. And how do you compare efforts to sow doubt through questions as opposed to statements? How, if at all, does the presence of counsel affect the suggestions for providing effective and proper evaluations? Well, it affects it a lot. First of all, unrepresented parties should certainly be given the opportunity to consult with a lawyer and to get their own feedback about something that's come up during the mediation. When you've got the lawyer there, I still like having the lawyers do that kind of evaluation, and I've even gotten to do it in joint session, rather amazingly. But I really like them to do it if I can get them to do it. And I think it may come across better to the plaintiff. I'm not kind of wedging myself between the plaintiff's counsel, let's say, and the plaintiff. I'm just, doing sort of, is it possible? Is it possible that a court could find against you? How might that happen? Can you explain that to the plaintiff? And then you'll hear the explanation. And it's pretty easy for a lawyer to do, because courts can have crazy sort of rulings. It's not that often, but it can happen. Or every case is not perfect. If it was, you probably would have settled it long before you got to mediation. So there are going to be pros and cons, and you can get the lawyers usually to talk about those. In a way, they're externalizing, right? They're going to blame it on the court and not on themselves. Okay, the ethics of mediator persuasion. We will talk some more about this, both in terms of self-determination and impartiality in later classes. But here's some general guidelines I want you to be aware of. So just so you know, in the materials I sent you the ethics packet that you use to analyze your agreements to mediate. And you got your state-specific ethics rules, assuming that a set exists. But there is a set of aspirational guidelines that were created by the American Bar Association, AAA, which is the American Arbitration Association, and what is it? Well, it's Conflict Society. I can't remember now. Association for Conflict Resolution. There we are, ACR. And they're known as the model standards, and they've been updated twice. The most recent set came out in 2005. So often when a state has not adopted their own ethics code, mediation community will often adhere to these model standards, or they'll have their own aspirational code that reflects the model standards. Similarly, the state codes often reflect the model standards, but that's largely because there's now quite a bit of consensus about what good mediation looks like. Okay, so standard 1B says, a mediator shall not undermine party self-determination by any party for reasons such as higher settlement rates, egos, increased fees, or outside pressure from court personnel, program administrators, provider organizations, the media, or others. So this is this caution against using heavy-handed tactics to get a settlement. So you want to make sure that you're creating space for voluntary decisions. So you're always asking how much pressure is too much And when does persuasion cross the line to coercion, which is clearly and explicitly prohibited by just about every ethics code I know. So another video clip. As you watch this caucus, ask, did any of the mediator's interventions cross the line from the appropriate persuasion into inappropriate pressure or coercion? Be specific. If none of the mediator's interventions cross the line, did his approach as a whole? Why or why not? You've already seen the Vitakis v. Valsheen video. That's a good example of where the mediator probably crossed the line. All right, another video clip. If a mediator is entitled to apply more pressure when dealing with, or let me start over. Is a mediator entitled to apply more pressure when dealing with represented parties on the assumption that their counsel will protect them? And I think that's a good question. I just talked about it a little bit. Are you entitled to apply more pressure? I'm not sure about that. I think that you can do it and be less concerned about undermining party self-determination. How about that? Okay, informed decisions. What is adequate disclosure? So mediators can manipulate the process by making active statements or passive non-disclosures of information. And see the problem 10 at page 329. So it's an example. It's a what they're really talking about here is doing the sort of evaluation that's incomplete and kind of paints the worst scenario in one caucus room, and then the mediator trots down the hall and repeats the process in the other caucus room. So it's manipulative in the sense that the goal is to try and get settlement, but it's not necessarily to get there by allowing parties to exercise really good decision making based on full disclosure of information. And so this is why, in terms of best practices, you want that evaluation to be even-handed and complete and well-informed. So here's another section of the model standard. It's 6A4. A mediator shall promote honesty and candor between and among all participants, and a mediator shall not knowingly misrepresent any material fact or circumstance in the course of mediation. So the criticism of this rule is it prevents only positive fraud by the mediator. So you see it's knowingly misrepresent as opposed to omit a material fact. And the authors caution that you need to keep in mind that non-disclosures can undermine public confidence in the process over time. You know, you got to remember, no matter what you're doing, that the parties, especially if they settle the case, may talk about the experience later, and they may find out what you said in each one of the caucuses. And so they're gonna, if it comes off kind of stinky, they're going to be talking about it in a negative way. They're going to feel manipulated, and they're not going to like mediation as much as if you had done it with the utmost integrity. So just be mindful that, again, we've got to protect the reputation of the courts, the reputation of the field, and so we want to be doing this in a really high-quality way. They are concerned about tailored evaluations, and you can take a look at the problem. This is a cause for concern if the mediator deliberately exaggerates the risk of non-settlement or the benefits of settlement in their evaluations, especially if the parties are not represented by counsel. So again, this is just shading the evaluation with settlement more in mind than informed decision-making by the parties. Stunted legal evaluation, so evaluations that emphasize the risk of litigation without recognizing strengths of the party's case. So this lacks that balance that we've talked about before. Okay, so video clip involving the Di Lorenzo mediation. Lord outlines Di Lorenzo's contractual breach and his failure to provide a deadline in the contract. So that's a legal evaluation. Then advises he has not shared this information with the plaintiff so as not to build her case. So apparently the failure to put a deadline in the contract undermines DiLorenzo's case. But the mediator hasn't bothered to tell the plaintiff that this is a strength in her case, and she's unrepresented, remember. Can we square this approach with the core value of party self-determination? Shouldn't Ms. Wilson have the same information? And the fear, of course, is that you embolden that party to be more stuck in their litigation position. Okay, so self-determined decisions battling lawyer interference. Ah, yes. So sometimes there is a conflict of interest between the lawyer and the client. The lawyer may be wanting to settle for a higher dollar value because, especially if they're working on a contingency fee, that's going to be a higher recovery for them. So if the client wants to settle at a lower price, you may see tension between the lawyer and client just based on that. There could be other reasons that the lawyer's interfering with the settlement process. So what should the mediator do when the attorney or other agent impedes the client's decision-making process? And again, to me, this is an opportunity to probably do it in a separate caucus, ask permission to meet just with the lawyer, and then explore it using why questions again. Okay, now some really technical stuff. Information versus advice. So the Model Standards 6 provides, mixing the role of mediator and the role of another profession is problematic, and thus a mediator should distinguish between the roles. A mediator may provide information that the mediator is qualified by training or experience to provide only if the mediator can do so consistent with these standards. So, which hat are you wearing? Be careful that you keep the hat you're wearing on and not switch to another hat. Your information, it doesn't have to always be legal information. It just has to be information that you are qualified by training or experience to provide. And so let me go back. So consistent with these standards, so all the rules governing self-determination and impartiality are going to be triggered when you're giving legal information. And the Virginia rule is even more explicit about this. We'll talk about it, I think, in more detail, either later in this class or in a later class. Okay, so one of the questions that comes up when you're doing any sort of evaluatory work, especially legal evaluation, is it the practice of law? First of all, is mediation the practice of law? And frankly, this debate went on for a while, and any smart agency regulating UPL has figured out that no, if you're doing this consistently with the guidelines, mediation is not the practice of law. That doesn't mean that there haven't been regulators that have gone after non-lawyers who are engaged in a more evaluative practice, and they apply these very loosey-goosey tests. And the reason I know a lot about this is I wrote extensively on this issue. The article I wrote is book length, and it focused on a therapist mediator out of New York who was practicing in Connecticut and got hauled into a grievance procedure. And because the test for UPL, unauthorized practice of law, was so loosey-goosey, she ended up entering a consent decree that she had no idea how to comply with and quit practicing in Connecticut. So it's a sad story. Since then, Connecticut actually changed their definition and made it a little more consistent with the realities of the role that mediation is now playing. This is a very technical thing. I can spend 2 hours talking about this, so I'm just going to highlight the issue. The book talks about some of this in more detail. Very difficult topic. Okay, so in our next class, We're going to be talking about dealing with impasse, caucus techniques, and you've got some readings, and I've given you something you can put in your handbook, Mechanics for Caucus. You're going to be watching one video clip, and then I am going to be demonstrating this caucus procedure in the Takesha Maria role play, and you're going to get a chance to do it in cross-view rope. Or if you're sick of that role play at that point, I'll give you another one. All right, so that's it for this class, and so I will see you in the next webinar. Bye now.